Mr. Lewis.
Sir, the Protection from Harassment Act has protected and provided redress for harassment victims. This bill will amplify these positive effects by making it easier for victims to seek redress and recourse for harassment-related behaviours, and by targeting new social trends, such as doxing and increased incidences of fake news. That being said, I would like to make some recommendations to better support victims by improving responses of enforcement personnel and by increasing the use of counselling and mediation. I would also like to seek clarification on the scope of the new offence of doxing. So, sensitivity and tact are needed when assisting victims of harassment to avoid secondary victimization by law enforcement. In the online talk show series Under the Carpet, Deborah Tang highlighted the need to train first responders on the handling of harassment, assault and violent cases victims. From her interviews on the show, she noted that, quote, "Too often victims are made to feel ashamed, foolish or disbelieved. Many go away wishing they had never made a complaint or reach out for help. And if it should happen again, they will never speak up," unquote. It also emerged through the show that there have been instances where victims felt they were not taken seriously because they may not have exhibited behaviours that law enforcement deemed typical of assault victims. The legislative amendments to strengthen protections under POHA will not amount to much without an environment where victims feel safe to speak up. Training our law enforcement officers to better manage these cases with tact and empathy is crucial in creating such an environment. Sir, carving out a separate regime in the form of the new Protection from Harassment Court, PHC, for those who seek help under POHA implicitly recognises that victims of harassment face unique vulnerabilities. I'm aware that changes have been made by the Singapore Police Force to investigative processes and court procedures in order to create a safer space for victims of sexual crimes. Can Minister confirm if such changes also apply to victims of harassment? Do victim care officers who are specially trained in victim care management also handle victims of harassment? Next, I'm heartened that amendments in this bill seek to provide quicker relief for victims of harassment by making certain breaches of protection orders, POs, and expedited protection orders, EPOs, arrestable offences. Physically restraining the harasser addresses the immediate threat posed by the harassing behaviour. However, because the harasser will not be detained indefinitely, the victim remains at risk of their harassing behaviour after the harasser is released. One of my residents had a personal protection order, or PPO, against her husband. They were going through a divorce, and their relationship was tense. The PPO was issued in July 2016. In August, she was repeatedly stabbed by her husband in front of her youngest daughter. She later died of her wounds. Her husband was sentenced to 10 years imprisonment, but any punishment meted out can never heal the loss of a mother for their two daughters, or undo the trauma suffered by the youngest. The PPO was insufficient to prevent her husband's attack. While the PPO operates in a separate regime under the Women's Charter, harassment victims who obtain a PO or EPO under POHA might find themselves in similar threatening situations by the harasser. Therefore, will the Minister look into immediately attaching a social worker to such cases once a PO or EPO has been issued? A social worker could consistently monitor and assess the case and identify any worrying irregularities in the harasser's behaviour in advance to prevent ill-fated cases like that of my resident. Currently, when ordering POs or EPOs, the court can include the condition that the respondent and victim attend counselling or mediation. Will the Minister consider making it mandatory requirement that the court considers referring counselling and mediation option for parties and making such an order where appropriate? Lastly, the bill introduces a new offence of doxing, which signals the government's firm commitment towards addressing new and upcoming form of harassment. This is especially welcome in the time of online vigilantism. It's becoming more rampant in our society. However, as mentioned by many in this House, there is some ambiguity as to what constitutes doxing, as defined under the bill. A 2016 incident illustrates this. Many have shared examples, and I will share, of course, an animal one. In 2016, a story emerged on Facebook of a driver who ran over a dog from a dog shelter and drove off in a hit and run. Her vehicle plate number was posted on Facebook with a request for anyone who knew the identity of the driver to text or message a private number. Netizens used the posted plate number to obtain and publish online the woman's personal particulars. The car owner and her employer were harassed online by angry netizens. It subsequently emerged that the owner had in fact not been driving the vehicle at the time and did not run over the dog. This story highlights the danger of internet vigilantism and the ambiguities in the definition of doxing as an offence. Would the initial action of publishing the woman's vehicle plate number on their Facebook page be considered doxing? First, would a vehicle plate number fall under the definition of identity information? The amendments include illustration D, which references the situation in which an individual X records a video of Y driving recklessly in a car and posts the video on an online forum. While illustration D goes on to state that no offence has been committed because X posted a video with the intent to warn people to drive defensively, it is not clear from the example whether a vehicle plate number alone would constitute identity information. Second, was there intent to cause harm, alarm or distress in a situation where initially they were simply trying to find out who was driving the car and hit the dog? Could the defence that the conduct was reasonable be raised here? While there was a request to help to identify the driver, it was also expressly stated that the information should be sent to a private number. This story highlights my broader concern about the difficulty in determining whether there was intention to cause harm, alarm or distress by the publication of identity information, or whether the conduct was reasonable. Parliament expressed a preference to leave interpretation of POHA to the courts, as POHA offences are highly dependent on the factual matrix. The courts have stated that the intention being a tort process can only usually be proved by drawing inferences from the surrounding circumstances and the action of the accused. Can ministers shed more light on what the courts should consider in drawing these inferences? Further, can more examples of permissible and impermissible publication of identity information can be provided either in the minister's response or through guidelines or informational materials from the ministry? This will be helpful for guiding the conduct of the public, who should not be hauled to court before finding out whether their actions constitute an offence or not. Third, regardless of intent, there should be a bright line prohibition on revealing certain categories of identity information, such as NRIC numbers, passport numbers, addresses, and phone numbers. These categories of information are very sensitive, and anyone who publishes this information must reasonably know of the risk that the information may be abused by the public in ways that might cause the individual harassment, alarm, or distress. Notwithstanding that the publisher did not expressly or specifically intend to do so, he or she should be taken to have acted in willful disregard of the risk. The nature of this category of information means that they can be misused for nefarious purposes with particularly devastating consequences for the individual. As such, it might be prudent to prohibit publication of this category of information regardless of intention. So notwithstanding the above clarifications, I support this bill, which will better protect and offer redress to victims of harassment.